Turin received.
Mr. Dale, you say services, but what was he in fact doing? Research as contemplated by the treaty?
Yeah, we can see that he was conducting research within the meaning of the treaty. I mean, developing the detector as part of this upgrade, it involves some cutting edge stuff. It's more than just assembling parts that you get, from a supplier. So it is sort of cutting edge stuff as I understand it, but it wasn't his research. Even he concedes on page 14 of his brief.
Why does that matter?
Because the research is JSA's research, and he is performing a service for JSA in assisting in that research project.
Does the treaty make that distinction?
The treaty makes a distinction between wages, salaries in respect of employment on the one hand, and grants, allowance, and similar payments on the other hand. So he is the recipient of salaries in respect of employment, conducting research, rather than the recipient of a grant.
What would a grant have had to look like? What kind of scheme do you think this treaty contemplated?
Yeah, well, so in 1980, the IRS had put out a revenue ruling that sort of explained the difference between, these sort of compensation for services and grants. And it dealt with 2 cardiologists who were temporarily present in the United States under the Japan Treaty, which provided an exemption for grants, allowance, or awards. And under that ruling, the IRS said that one of the cardiologists who carried out research according to a plan submitted with a grant application was not directly supervised by an employee of the foundation, had the right to the product of his research, and was entitled, but not required, to publish the results of his research. That cardiologist was a recipient of a tax-exempt grant. The other cardiologist was paid an amount to do research on a project chosen by the foundation, was supervised by the foundation in what was essentially an employment relationship, and had no rights to the results of his research. That cardiologist was receiving compensation for services, and his pay was not tax exempt. Dr. Baturin's paycheck is like the second cardiologist and not like the first cardiologist. He was paid to work on a Jefferson Lab project. He reported to a supervisor who told him his duties. He wasn't entitled to the results of his research. So if we follow that revenue ruling, there's no doubt that Baturin did not receive the grant. That revenue ruling was the first of 4 revenue rulings that immediately preceded the negotiation of the Russia Convention. And those 4 revenue rulings laid out, with respect to 17 different treaties, how to distinguish between compensation for services, which is taxable, and grants, allowance, and awards, which are not taxable. That is the context in which the Russia Convention was negotiated. The very agency that was charged with implementing and enforcing these other treaties, and was charged with negotiating, implementing, and enforcing the Russia Convention, so ruled.
Sorry to interrupt you, but so with respect to these, to your definition of a grant, could any portion of that grant, under your view of things, be used for personal sustenance and expenses and the like? I assume that's part of what the money for the salary went to, but under your view of things, the grant money must be used exclusively for the research conducted, can't be used for personal expenses? No,
that's not our position at all. I mean, an allowance, for instance, a per diem allowance.
Well, why isn't that this case then?
Well, because if you pay somebody in a grant or an allowance, it enables them to do research. You're not providing a service to the grantor. You are conducting your own research with the aid of a benefactor in the form of the grantor. The key here is the sort of quid pro quo employment relationship you do this work and you get paid. You don't do this work, you don't get paid.
So, I guess the question is whether or not this research was undertaken for the public interest or for private benefit. And your view is that it was primarily for the employer, not for the benefit of the public?
Well, so we conceded that point principally because Jefferson Lab is a Department of Energy facility. So it's not, it's not, although JSA is a private company, there are obviously public benefits that come out of having an electron beam particle accelerator that studies the basic building blocks of matter. In terms of how that particle accelerator is being conducted and what is necessary, a lot of that was kept under wraps. Dr. Baturin had to take a lot of security exams. He was given access to a lot of confidential information. So the results of whatever work was being done was not necessarily made public, but we conceded it in the tax court that the public benefit element of that, because it was a Department of Energy.
Mr. Dale, I have a question. The tax court was very, very broad in its holding. At the bottom of page 19 of its opinion, it says, we conclude that the petitioner is the recipient of a grant, allowance, or similar payment. What is a similar payment from the government's position?
Well, some things that are called grants, that are grants, may not necessarily be called grants. They may be called stipends or fellowships or scholarships, or other. The term grant, is not necessary. But what is necessary is this sort of relatively disinterested, no strings attached, no quid pro quo grant.
Well, grants and allowances are they similar in your position?
Well, no. I mean, the grant isn't for specific expenditures, where an allowance is generally estimates specific expenditures.
Right. And so what would be a similar payment then if grants and allowances are not similar? In other words, how do we figure this out? The tax court's holding, it's very, very broad, isn't it, by saying that it's a similar payment? Or may have been a similar payment. He was the recipient of a grant, allowance, or similar payment. That's a pretty large basket. So tell us what the parameters of that basket are.
Well, again, that's what those revenue rulings were talking about. Is the payment, is the recipient of the payment expected to devote their time exclusively to research training, or were they expected to perform services for the payor? Do they participate in Social Security and other benefits? I mean, those sort of things are, Social Security is not a grant in that context. I would also note that under the treaty, wages, salaries, and other similar are taxable. So that language is fairly broad too.
Do you rely on Bingler?
Do I rely on
Bingler, the case? Bingler?
So Bingler upheld the Treasury regulation that was interpreting the term fellowship grant.
Right, but I hadn't heard you talk about it at all here.
Yeah, well, I used the language relatively disinterested, no strings educational grants with no requirement of any quid pro quo on behalf of the recipient. And so while that term refers to fellowship grants, which I think are more in the educational context, if you take out, the word educational in that discussion, then I think Bingler is directly on point. It's persuasive at the least in that it says this is the ordinary understanding of the term grant. Recipients of grants don't really think they work for the grantor. They think they are the recipient of something and then are able to do work because of the generosity of that benefactor.
Well, is there any indication that the whole Bingler analysis was incorporated into the treaty? I mean, is there anything in this record that tells us that, or do you know anything?
Well, so the Bingler analysis was incorporated into the Treasury regulation.
Right.
It was incorporated in the revenue rulings.
So it's United States law.
So it's United States law to that extent.
We are the country, and so the treaty talks about the country where the work is being done. Is that where you're going? And we are the country.
Right. We are the country. We are the host country.
Right.
But yeah, so the revenue rulings and the Treasury regulations preceded negotiation of the Russia Convention, and they are extremely strong evidence of the intent of the Treasury Department when they negotiated the Russia Convention.
So has anyone asked the State Department their views on this?
We consulted with the State Department as part of our briefing in the case, and they concurred with our analysis.
Do you tell us that anywhere in the briefs?
I don't.
You just told us that, right?
Yeah, you asked, and yeah, we tried to make sure we covered our bases on that point. And the thing is it's kind of Hornbook treaty interpretation law that the interpretation assigned to treaty provisions by the executive branch agency charged with enforcing and implementing and negotiating the treaty is given great weight. I think it's even in, we cite a couple of Supreme Court cases to that effect in our reply brief. It's even in the restatements, Fourth of Foreign Relations, Section 306, I believe. So the IRS's interpretation is given a lot of deference. I think I'm out of time.
You are out of time. Thank you very much for your argument. I think you have some rebuttal. Mr. Roper?
Thank you. Good morning, and may it please the court. Aaron Roper is court-appointed amicus in support of affirmance. For 3 reasons, this court should hold that Dr. Paterin is entitled to the treaty's Article 18 tax exemption for research grants. First, the term grant has a settled meaning in the research context, specific funds for specific research. The treaty's references to research and scientific organizations incorporate that meaning. Second, the IRS—
I'm sorry, where do you get that meaning?
That meaning comes from the generally accepted understanding of research in this area. It's the ordinary meaning. We cited a host of federal guidelines and grant-making rules to show how researchers understand the term. For example, we have the National Science Foundation manual.
And has the Supreme Court told us that those are appropriate things to look at?
As evidence of ordinary meaning, I think you can look at any use of the word contemporary with the interpretation.
I thought we looked at what the law of the state was, being the United States in this instance. And I didn't get that any of those were in some definition in the law of the United States, but help me here.
Of course. So first, the treaty directs you to read the term in context is the first order interpretive principle in Article 3 of the treaty. And then second, it directs you to the laws of the United States. We agree. But the laws of the United States, as the IRS concedes, do not define the term grant generally, and they do not define the term research grant. Instead, the only thing the IRS is able to point to here are these regulatory interpretations of the term fellowship grant.
Yeah, but that is the only thing that we have. I mean, that's closer than nothing.
I think the context is the closest, Your Honor. I mean, we have this well-accepted meaning that the IRS hasn't taken issue with. I think ordinary meaning is the first order principle here. But I don't have any reason to quibble with the fellowship grant regulations account of how academic fellowship grants work.
Can you talk just a tad louder? Maybe it's just me, or maybe the microphone is. Are you?
Of course,
Okay.
I can speak up. Yeah, so we don't have any reason to quibble with fellowship grants, but the operation of grants in the research context is just simply different. So if you adopted the meaning from fellowship grants, you'd be knocking out a huge swath of totally ordinary, everyday research grants as researchers understand that term, totally gutting this specially negotiated provision that was intended to provide benefits to researchers.
Okay, Mr. Roper, is it your position that a person can be an employee for one purpose and a grantee for another?
It is. It is.
Okay. Could you tell us then what are the boundaries for this duality? I mean, because here we have the W-2s, we have the employee benefits, we have pretty strong evidence of an employment relationship. So where does the balance come from? What are the outer limits? Help us with that.
Yeah, so we don't view it as a duality. We think the fundamental question is, was there a grant? And the fact that there's evidence of employment is totally consistent with that. I mean, it is an extremely common practice in everyday research to pay out grants to researchers in the form of salaries.
Right, but we know he was treated as an employee in certain very well documented aspects, the eligibility for the employment benefits, the W-2. So how do you then reconcile that with your position of the grant? I haven't heard that really yet.
So we don't think those are bad facts for us at all. The central question is, was there a grant in the first instance? And then if that was dispersed as an employee compensation, that's totally normal. So,
okay, where is the evidence of a grant? So I've been troubled by that too. You know, I wonder if it didn't, there wasn't a lack of evidence in front of the trial court perhaps because the plaintiff was pro se. You know, it's unclear exactly what happened, but where is the evidence of the grant in this record?
So I'll readily agree that it's not the clearest record. I think the strongest place we can point to is Dr. Baturin's testimony, most clearly at pages 266 to 70 of the appendix. He testifies repeatedly that Jefferson Lab filled a box or bank account of money for his benefit for his specific work on subatomic particle detectors. And the tax court did not clearly err in understanding that as factual testimony about what he was told was happening to him. The IRS obviously—
But how would that be inconsistent with paying a salary?
We don't view it as inconsistent. Our position is that it is fully consistent to have a grant that is then dispersed to the individual as employee compensation. So say—
Well, I understand, but my colleague has been asking you, we understand the part that looks like compensation, but we don't understand the part that looks like grant. And you're saying to me they're not inconsistent because you can distribute a grant in this way. True enough. But where is the evidence that it is just that is grant?
So I think the grant is the filling the box of money. This initial, they set aside, taking $75,000 and putting it aside and saying, Dr. Baturin, this is $75,000 we are earmarking for your support for this specific work you are going to be doing on this specific subatomic particle detector.
Okay, how does the escalation in salary then play into your analysis, or escalation in remuneration?
So the task court found that the remuneration did not increase, and that finding was not clearly erroneous. So there's conflicting evidence on this point. If you look at every iteration of Dr. Baturin's immigration paperwork, it says he was getting $75,000. Yes, the W-2s have a different amount. It's unclear what that extra money is, if it was a family allowance or conference attendee or what have you. Obviously, the IRS could have asked Dr. Baturin about that difference at trial. This was all in the record. The IRS chose to ask only 9 questions on cross-examination and offer no evidence. So on that record, I don't think the tax court's finding is clearly erroneous. Even though if you thought the grant amount was going up year to year, I don't think that would be a problem for Dr. Baturin. Grants do sometimes bake in cost of living adjustments. For example, if you look at the NIH appropriation statute, that pegs grants paid out of salaries in the NIH grants to the federal pay scale, which obviously goes up year to year. So that wouldn't be a problem for Dr. Baturin. But ultimately here, Dr. Baturin put forward credible testimony, credible evidence in the form of his testimony. I agree it's ambiguous, but once he'd done that, the burden of proof shifted to the IRS under section 7491A1 of the tax code. So to the extent you think this record is ambiguous or there are gaps here, those are really failures of the IRS's burden of proof. All Dr. Baturin had to do was, as a pro se party, put forward this credible evidence, which he did, and then the IRS needed to rebut him. And it simply fell down on its burden in this case.
Can I ask you, the doctor is now here on an H-1B visa, is that correct?
He was at the time of the most recent documents in the record. I don't know his current status.
As of 2012?
Yes.
Right. And under that visa, he is an employee, correct?
He is a worker, yes.
I beg your pardon?
I think worker is what the document uses, yes.
Well, for our
But
purposes
yes,
here,
yes.
he was being employed rather than receiving a grant.
We don't know what he was receiving in those years. There's not document evidence about what the initial set aside was, but there's no evidence.
Well, did he
for it.
pay a tax on it?
We don't know from the record. The IRS
Okay.
didn't ask a question
All
about
right.
that.
So, well, let us assume for the moment here that if you're on an H-1B visa and you receive money, it is taxable income. Just bear with me. Okay, what things was he doing in 2012 that he hadn't been doing in 2011?
So we don't have any record evidence about his specific duties. Again, the IRS didn't ask that, didn't build a record for it. But I think the key is not the duties. The key is what was the initial structure of the compensation? What did the grantor say up front? Did they say, you're just going to be getting money biweekly as long as you work? Or did they say?
Well, we don't have any evidence of that either, do we?
We have his testimony that there was a specific set aside. I think that is
A
the key.
specific what?
Set aside. They said, we are filling a box of $75,000 for you. That is
Right.
the grant.
But does that is your position that lasts indefinitely?
My
That's
understanding,
for 20 years?
no, it was an initial 2-year term. So it would have been a 2-year grant of $75,000 a year. And then they renewed the grant, which is common in the grant making field. You can get an extension of your grant with additional funds. From Dr. Matern's testimony, that is what happened here. And that is how the tax court understood it. And again, this is
It sounds like there are lots of things that aren't in the record here.
yes.
Maybe are necessary, was necessary for a remand for us to really understand what's going on.
So respectfully, I don't think a remand would be appropriate because it was the IRS's obligation once Dr. Patern had put forward some credible evidence for them to rebut him. So I don't think the IRS should be getting a second bite at the apple on its evidentiary failures at trial.
Well, if we determine that the Bengler framework applies, and there's nothing in the record of what Jefferson Labs gets out of hiring Dr. Pretorian, should we then remand for fact finding?
Possibly, but I would just really push back on the idea that Bengler is relevant here.
Oh, you don't think Bengler's relevant?
Correct.
Okay.
Our position is that Bengler is talking about scholarships and fellowships. I don't think there's anything incorrect about his characterization of how those work, but this is a case about research grants, and the practice is just different. And I think that difference is relevant to determining whether the grant was actually being used for the purpose. So suppose, for example, that you had a Russian student come in claiming to be the recipient of a scholarship, but a scholarship grant, but his only evidence was a W-2 and biweekly payments. I think the IRS would rightly look really askance at that because scholarships aren't typically dispersed biweekly and you don't get a W-2. I mean, you get a lump sum at the beginning of the semester and you get a different tax form at the end of the year. So in that case, the evidence of employment would be a problem. But in the research setting, it is extremely common to have this employment structure.
And how do we know that? Whereas you keep telling me things that aren't in the record. So you had an expert testify that was particularly common?
No, we're looking to ordinary meaning here from the government's own documents about how it structures its own grant programs.
Okay.
The National Science Foundation and the NIH are some of the largest grant-making entities in America. They fund billions of dollars of basic science research, like Dr. Patern was doing, with the government's own documents. They haven't disagreed that that is how the practice ordinarily works in this setting. And I think there are really strong indication of ordinary meaning in this area. Again,
I'm sorry, what haven't they disagreed?
of course, Judge Motz, they haven't disagreed with our account of how grants work for researchers. They haven't disagreed that it is extremely common for a researcher to have an employment relationship with the grantor or the conduit institution, and then to get their actual money in the form of a direct deposit with a W-2. These are all extremely common, ordinary practices for researchers.
Is it your contention that all researchers get grants?
No, it's not. It's extremely important, and this case turns on the tax court's specific fact finding that there was this advanced set aside here for Dr. Patern to work on this specific research project. That's crucial, and that's the only reason that he won in the tax court.
Does it matter that the tax court apparently also found that the continued payment of any grant money was subject to the availability of funds?
No, it does not. I believe that finding is supported by the record. The tax court's reading of the letters there is reasonable, but it is also not uncommon for grants to be contingent on funding. I mean, if you are the recipient of a multi-year NIH grant and Congress just doesn't appropriate money in the second year, you don't become a judgment creditor of the United States. Your grant says up front, this grant is subject to federal appropriations. And if Congress doesn't appropriate the money, you're out of luck.
What about the separate finding that the payment of a grant was subject to satisfactory performance?
That as well. Grants set out a detailed list of conditions that grantees have to comply with the grant if the grant terms aren't being complied with.
And how do we know that?
From the same sources, Your Honor.
What same source?
From the federal grant guidelines for Science Foundation grants, NIH grants. You can look through, you see hundreds of pages of criteria that federal grant recipients have to comply with.
And all that's part of the records. Really, the point I'm getting at is to almost everything that we've asked you that might be an unfavorable fact for your position, you say, well, it's not in the record. And it seems to me that you rely on a lot of stuff. You rely on a lot of stuff also that is not in the record.
I think the difference, though, is that we're answering different types of questions. The things the IRS doesn't have in the record are factual questions about what happened in this case. What we're pointing to is just evidence of how people understand the word in ordinary English, just like you'd look to a dictionary that's not in the record or a case that's not in the record. I mean, we're not saying that these grant guidelines are somehow incorporated into Dr. Maturin's situation. We're looking to them as evidence of how an ordinary speaker of English in the setting would understand the term at the time the treaty was ratified.
I hear what you're saying, but I don't know that that gets us any closer to what the law is than what you're objecting to from the IRS.
Well, then let me point you to Article 3.2 of the treaty, which says that undefined terms as a first order principle have to be read in context. And here the context is that it's talking about research grants. So I think the treaty is directing you.
The closest thing we have to anybody interpreting research grants is the Bingler case.
I respectfully disagree. The Bingler case is interpreting the term scholarship or fellowship grant. In fact, when it's
educational grants, no strings educational grants. There's no requirement of any substantial quid pro quo from the recipients.
And the statute it's interpreting there is a statute that exempts scholarships or fellowship grants. So we're in this fellowship setting, and our position is that that is just simply a different context. In the academic fellowship setting, you do not have the same common practice of paying out grants in the form of employee compensation. So the Supreme Court was interpreting the term in context, just like we're doing.
I mean, your whole position is that Bangler is bad law, that it's outdated. Two courts of appeals have recently relied on it.
No, our position is that Bingler is just defining a different term. Those two court of appeals cases that the IRS is talking about were about interpreting the term scholarship or fellowship grant, the actual statute that the regulations and that Bingler are interpreting. This case is about a different term in an entirely different body of law. And in this setting, it is extremely common to pay out grants in the form of salaries.
When was the United States-Russia treaty signed?
It was signed in 1992.
So, Mr. Roper, I think this gets back to a question that Judge Keenan asked earlier, is that it seems like every indicia that would suggest this was an employment relationship, you say that it's not necessarily inconsistent with that of a grant relationship. So what would have had to have been different in this case for your position not to prevail?
I think if Dr. Maturin had not testified that there was a box of money or a bank account filled for his benefit, he would have lost, because then the only evidence in the record would have been an ordinary salaried employment relationship, which standing alone is not a grant. Our point is simply that grants and employment are not inconsistent. And so we have to look at the record and see if there is evidence here of a grant.
And how do you take that, a box or what does that mean?
I take Dr. Maturin and the tax court with clear error deference took Dr. Maturin to be saying that Jefferson Lab had set aside this money for him. It was earmarked in advance. We are putting $75,000 aside. This is going to be what's going to pay you for this year. This is special guaranteed funding for you. It's not just an ordinary line item in my employer's budget that they're going to pay me X amount of dollars if I work there for the whole year. This is really a more designated set aside. which is the ordinary understanding of grant.
What if an employer put aside in a box, a literal box, the money to pay the payroll?
If they described it as guaranteed upfront, yes. If there was also the specific project, I think that would be a grant. I also just wanted to underscore really briefly the dramatic consequences of the IRS's view, given how extremely common this relationship is. If you adopt their theory, you're knocking out a huge category of totally ordinary research grants from the treaty's protection, which I think you should be very hesitant to do given the special benefits here.
Thank you very much.
Thank you.
I think that you have another person that wants to.
Yes. Let me change the mic.
Thank you, Your Honor. I would like to draw your attention to IRS instructions for J visa taxpayers. Those are document 38 and 39. These instructions reference tax treaty about 130 times and J visa 16 times. Details may be found in my brief document 40, pages 24, 28. Basic instructions for exchange visitors are given in document 38, page 11, section income connected with trade or business. From this section, we read that J1 visa holder must include his salaries on line 22 of the form 1040 NR, tax return form for non-resident aliens, page A308 of the appendix. Note that line 22 is labeled as tax income exempt by a treaty. Then he must attach his W-2 form with salaries, indicate tax treaty, foreign country, and relevant article. He also must attach his exchange visitor certificate, DS 2019 form, page A314. This form specifies the funds reserved for him for the whole program, up to 5 years. The last is required by document 39, page 26, section identification number for J1 visa holders, and similar in document 38, page 8. All that obviously means that, in fact, IRS recognizes the exchange visitor funds, including salary, as a subject to the tax treaty for 5 years. That's why IRS made a positive decision in 2010. And also I would like to mention that ordinary employment is forbidden within the program, within the exchange visitor program. It's A90, page A90 of the appendix.
Doctor, thank you very much. We appreciate your argument. And I just want to tell you that you had a fine amicus representing you. As good a lawyer as I've ever seen. So you should feel very confident that your position has been put fairly before us. Thank you.
Thank you.
Thank you, Your Honor. I guess I can respond just sort of briefly to the contention that the IRS forms and regulations and J1 visa status automatically entitle the recipient to an exemption. J1 visas cover a wide variety of exchange visitors. Some are scholars that are entitled to a tax exemption under various treaties. Some are, subject to ordinary employment. The most common, I think, you might be familiar with, are au pairs and summer camp counselors or temporary summer workers. Those persons here on J1 visa are subject to taxation under every treaty, as far as I'm aware. As far as the testimony about the box of money, we have, and I think Dr. Paturin's brief sets it out, is he's basing that on his reading of the regulations involved. He testified, the court asked him, so the money is secured, and then Jefferson selects the person to be part of the program. And he responded, right, yeah, it's according to these procedures described in this 22 CFR 62. What happens in reality, I'm not sure, but if they follow these procedures, then, and then the court cuts him off and says, 22 CFR outlines those procedures, and the witness says yes. So there's not an actual box of money at Jefferson Lab that's, got Dr. Batorin's name on it.
Does that make any difference to his argument?
It doesn't that much in terms of, look.
Remember Al Gore and the locked box?
So, look, let's say, JSA budgeted money ahead of time for its exchange visitors, which I think it does have to, under State Department regulations, ensure that it's going to have funds. If Dr. Batorin comes here and works, it's going to have the funds to pay him for his employment. And the State Department does oversee that program. It relies on private sponsors to do that work, but you do have to be solvent, and there are conditions to participating in the program. But at the same time, there's another State Department regulation, I think it's 6212, that says the exchange visitor has to have enough funds to arrive and support himself. So, they're ensuring that people don't show up in the United States and then, under shady pretexts. But even if the money is earmarked in advance, let's say, for instance, Eli Lilly and hires a foreign researcher to come over and conduct clinical trials on a new drug it's developing. And Eli Lilly gets, the benefits of that research. And, but if it budgets that money ahead of time, I think under Amicus's interpretation, like that would be a tax-exempt research grant. It's hard for me to see the distinction between just hiring a private researcher and giving a grant. In this case, there's no grant application. There's no grant funds given. Nobody called it anything a grant. There was no award to JSA. Even if it is the case that, sometimes a researcher might affiliate with a university, make an application, and then the grant would be awarded to the university first and then paid to the researcher. And I think that's the conduit line of cases that the tax court was talking about in the opinion. This is not that case. There's no award to JSA that then JSA gave out in the form of the salary. There's no grant evidence at all.
I hadn't actually realized this until oral argument. That's why oral argument is actually valuable. But it seems to me the gist of the case on the other side is that you have the testimony of the doctor and you don't have any pushback about that from the government, about what he says goes on here. And so that there's a failure of the government to come up with its position, and therefore we've got to affirm.
Yeah, that's the gist of his argument. But there is, every documentary evidence in the case is to the contrary. If you look at Exhibit 11J, it confirms. First of all, I think counsel said that there was no evidence that there was any as to what happened when he switched to an H-1B visa. But here's a letter from JSA that says, he was employed as a staff scientist when he on a J-1 research scholar visa and receiving full salary and benefits as all other employees. And then afterwards, he's on an H-1B temporary visa.
I thought that was so, but he said that's not in the record.
Well, it's 11J sets forth, what, the IRS attorney asked JSA what was going on here, and the JSA furnished all this documentary evidence. And
was that in front of the tax court?
Yes. And so that was, that's chosen. At the time of trial, it was going to be a small tax, non-precedential case, and so I think the IRS was sufficient to rest on this documentary evidence. What what are you going to argue against it? There's testimony, but the testimony is clear that the testimony is based on Dr. Baturin's reading of the regulations and not actually talking about what he was told by JSA or anything like that.
Mr. Dale, your colleague on the other side ended his argument with the sort of the doomsday scenario that if we rule against Dr. Baturin in this case, it's going to spell the end of grants and research-directed work as we know it. What is your response to that?
Yeah, I mean, this case is not a close case. I mean, this is a clear employment scenario, but, the regulations themselves say that his concern is that, well, what happens? Sometimes you have to furnish reports to the grantor and tell them, what's going on here. Well, the regulations themselves say that neither the fact that the recipient is required to furnish reports of his progress to the grantor, nor the fact that the results of his studies may be of some incidental benefit to the grantor shall by itself mean that the payment is not a grant. So it even allows for this sort of scenario that we're talking about, where you're providing reports to NIH and so forth. But there's a long history there's a half century of case law. There's a long history in the revenue rulings. There's 17 other treaties that are interpreted just the way we're saying that this treaty should be interpreted. That is extremely important context in interpreting the Russian.
I'm sorry, before you sit down, maybe I may have asked you this earlier and I've already forgotten the answer. So what would JSF, the JSA in this case, what would they have had to do in order to qualify Dr. Baturin as a proper research grantee?
Right. So I think evidence, you may not need all of these, but evidence of a plan that's submitted with a grant application and doing research according to that grant plan. It's not directly supervising Dr. Baturin, but Dr. Baturin provides reports of his progress. The product of the research is Dr. Baturin's and not Jefferson Labs. Dr. Baturin would be entitled but not required to publish the results of his research. If he was expected to devote his time exclusively to training and not perform services directly for JSA, not participating in Social Security, not eligible for ordinary employee benefits, no increase in stipends based on merit, then that sort of evidence would be indications of a grant type relationship. And those are all spelled out in the revenue rulings and the Treasury regulations.
Are grants labeled grants?
Are grants labeled grants? Most of the time, although they might be labeled a fellowship.
That's not necessary, but it's not unusual to have a grant labeled a grant.
No, I think if you're recipient of a grant, usually it's you've applied for a grant.
Right.
All right. If there are no other questions, we ask that the court reverse the decision to tax court with instructions to include Mr. Baturin's pay into his gross income.
Thank you very much. Thank you for your arguments. And I guess you all now will exit and second lawyers will come in. We appreciate your argument. Usually we come down and shake hands, but consider your hands shaken.
and prohibiting him from having social media accounts such as Facebook. In 2018, in light of the Supreme Court's decision in Packingham versus North Carolina, Mr. Morris moved to modify those conditions, among several others. The district court denied his motion on procedural grounds without considering the merits and reasoning that the Fourth Circuit precedent in O'Brien from 2002 precluded Mr. Morris from challenging the legality of his sentence under Section 3583E2. Now, as the court knows, this court issued United States versus McLeod, authored by Judge Motz during the pendency of this appeal. And that case invalidated the premise upon which the district court's determination rested. Consequently, this court must vacate the trial court's denial of Mr. Morris's motion to modify and remand to the trial court for a determination of the merits of Mr. Morris's challenge. I'd like to make 3 points today. First, Mr. Morris did what he was procedurally required to do pursuant to McLeod in raising a Section 3583E2 motion based on changed legal circumstances that could not have been raised at the time of his sentencing. He was sentenced in 2014, and the Packingham case was decided in 2017. Second, this court's recent decisions indicate that at a minimum, the district court is required to make that substantive determination as to whether or not the changed legal circumstances that Mr. Morris raised is in fact valid, and whether or not that affected the conditions of his supervised release. And the trial court must do that in the first instance. It is not for this court to make that determination in place of the trial court. And finally, Packingham and the recent opinions from this court did change the legality of Mr. Morris's conditions of supervised release, restricting his internet access. And what
Can I ask you, even without Packingham or anything else, Mr. Morris could have argued at the time of his sentencing that the conditions violated the First Amendment, couldn't he?
He could have argued that, Your Honor. Yes, he could have had a direct appeal following that. But when the Supreme Court issued the Packingham decision in 2017, it strengthened his the basis for a challenge of the conditions of supervised release. Packingham made it very clear that these restrictions on using the internet, particularly as it relates to social media, is restrictive on anyone's First Amendment rights, particularly if the conditions are not narrowly tailored to the actual conviction at issue.
I take your point, but what we're looking at here is whether it's a changed circumstance. And so is Packingham a changed circumstance if he could have made the same argument before Packingham?
It is, Your Honor, because what we've seen now are, following the issuance of Packingham, we've got federal and state courts applying Packingham to issues of relating to supervised release and making it very clear that the use of social media is a First Amendment right. We didn't have a case before from the Supreme Court elucidating or
No, and I do recognize that. But remember, my first question to you was, could he have made the same argument before Packingham came out? You said yes. So that's what I'm trying to do, is tease out how Packingham is a changed environment.
I understand, Your Honor, but if there were no change in circumstances, the Supreme Court wouldn't have needed to issue Packingham in the first place. I guess at the very bottom here is that determination of whether or not Packingham is meritorious or not as a challenge to the conditions of supervised release. That determination should be made by the trial court in the first
Ms. Martinez, just to follow up on Judge Motz's question, is your position that the argument that you made or counsel below made following Packingham was foreclosed before Packingham?
So I'd like to tease out that question first, Your Honor. So following the sentencing, Mr. Morris was represented by counsel. There was no direct appeal challenging his First Amendment rights at the time. When Mr. Morris was subsequently incarcerated, he was the one who raised the motion to modify pro se. And when he learned of the Packingham case, that's when he brought that particular challenge. So what we have here, Your Honors, is a pro se litigant finding a Supreme Court case that directly affected the conditions of his supervised release, conditions that he knew he would have to undergo upon him finishing his incarceration. And so that's when he brought that challenge, and it is a proper challenge under McLeod.
Okay, Ms. Martinez, what about our decision in Comer? I noticed you didn't cite it in your reply brief. It pretty squarely talks about the social networking prohibition unless approved by the probation officer. How does that factor into your analysis of what we should do today? If we agree with you that Packingham was a changed legal circumstance, then do we divide these two conditions up and send back the blanket prohibition to the district court for reconsideration, but deal with Comer here and the ban, or send it back as a package? And on what legal basis would we do that?
Sure, Your Honor. I would like to address the Comer case, and that case is an opposite both procedurally and substantively. On the procedural portion, Comer was a direct appeal rather than a Section 3583E2 claim. It was not a motion to modify.
Right, but why is that a distinction with a difference in this case?
It is a distinction without a difference in this case because the Fourth Circuit was able to look at the merits of the direct appeal of Packingham on direct appeal, whereas on a Section 3583E2 challenge, that issue was never dealt with substantively by the trial court. And therefore, that issue is not really in front of this court because there's no determination below. So
you're pretty much saying that the district court is in a better position to evaluate it in the first instance because the district court said at the outset that it couldn't consider these. Now, if we tell the district court it can consider these, then that's the place it should begin.
Yes, Your Honor, and not just that the district court is in a better position to do it, but under this court's precedent, it's where that determination should be made to begin with. And on the facts, Packingham was analyzed in a footnote in Comer, and they only looked at the issue of whether or not the condition of supervised release was vague in light of Packingham. And as applied to the defendant in that case, I think that Comer was correctly decided. The defendant in that case was using Facebook in order to lure her victims into sex trafficking, to disseminate revenge porn, and to meet felons to engage in personal relationships. Well, we don't have that here. Here, what we have is somebody who was convicted of possessing child pornography, but it was a non-contact offense. And under the court's decisions in Ellis and in Hamilton, there is a distinction between contact and non-contact offenses as it relates to sexual offenses. And Your Honors, you're not writing from a blank slate. Last year, we had two panels in this court decide two cases in light of McLeod. We have the DeBolt case and the Witten case. And in both cases, the trial courts determined that they didn't have jurisdiction to hear challenges to the legality of supervised release conditions. In Witten, the case was remanded back to the trial court because the trial court never made a determination as to the merits of the motion to modify. The opposite result was reached in DeBolt because in that case, in addition to the trial court saying that it did not have jurisdiction to hear the motion, it also stated that if it did possess jurisdiction, it would deny the challenge on the merits. And I think that's the key issue here, Your Honor, which is that the trial court never made that substantive determination. And so meritorious or not, the trial court's got to do that because that's where the jurisdiction lies in looking at these issues.
Are you agreeing for purposes of this argument today that the other issues have been defaulted, like the financial requirements and things like that? It seemed in your brief you mentioned them, but you didn't, you can't tie them to Packingham or McLeod. So it seems to me they're effectively defaulted. Is that correct?
So, Your Honor, Mr. Morris did challenge 8 conditions of his supervised release. We focused on conditions, I believe, 4 and 5 related
right,
to
but what is the
access.
legal basis for those going back to the trial court?
So Mr. Morris himself did not raise new legal circumstances, and at least according to my read of his particular motion, there were no changed legal or factual circumstances following his conviction. As amicus counsel, directed at going through the appellate process under the McLeod case, I'm not really in a position to speak to the merits of those others, only to say that there were no changed legal or factual circumstances raised as to the other 6 conditions of supervised release that were raised by Mr. Morris.
Can I go back to a question I asked earlier? So Witten is an unpublished decision, and it does, I think, support your position about what it means to have a change in legal or factual circumstances. But the question I asked earlier was whether at the time of sentencing, a challenge to these conditions was foreclosed by applicable precedent. And I don't think you answered that question. If it wasn't, then why would Peckingham or any other case be a change in a legal circumstance?
Yeah, Your Honor, to answer your first question directly, he was not foreclosed from challenging on direct appeal the conditions of supervised release, particularly as it relates to First Amendment issues. However, where we have new cases coming out of the Supreme Court, and in fact coming out of this court, particularly the Ellis case and the Hamilton case, which really talk about what it means to have social media, and particularly in the context of somebody with a conviction of a sex offense. These are cases that should be considered by the trial court when they are raised on a 3583E2 motion.
What if the trial court said, well, those are cases that whose holdings, or at least the legal analysis, was available to the defendant at the time of sentencing, and therefore I deny the motion?
Well, Your Honor, I guess we can say that about practically anything, that you would make an argument.
Well, not necessarily. I mean, if you got a Supreme Court case directly on point foreclosing your argument, I think that's a better case. But if the landscape is unplowed and it takes, someone had to be first, someone had to make the argument. Mr. Morris didn't make it, but that doesn't mean that he couldn't have made it.
I agree with that, Your Honor, but with the Supreme Court case at his back pocket, this case gets a lot easier to argue, I think. And finally, I just like to conclude, as my time is running out, that the government has not cited to any case post the McLeod decision in which this court has held that conditions of supervised release couldn't be, the legality couldn't be challenged on a motion to modify. And I think that's really important, because what we've seen now are at least 2 cases post McLeod dealing with this exact issue. And at least the Witten case goes exactly the way that Mr. Morris has been arguing. Now, if the court doesn't have any other questions, I'll reserve the rest of my time.
Thank you. Happy to hear from the government. Mr. Enright.
Thank you, Your Honor. May it please the court. Anthony Enright for the United States. The district court properly denied Morris's motion to modify his conditions of supervised release without reaching the merits, because it rested on grounds the modification statute doesn't permit under this court's decision in McLeod. Packingham did not, as some of the questions alluded to, create a new legal rule that was, in the words, to use the words of McLeod, not available at the time of Morris's sentencing.
Well, what about Ellis? I mean, Judge Gregory's opinion in Ellis is pretty strong, isn't it? I mean, he says rarely, if ever, will there be an absence of less restrictive alternatives than to deny total internet access. And he goes on to a great extent about the importance of internet access in today's society. So why, even though Packingham wasn't a case speaking to this type of situation, why isn't Ellis?
Well, Your Honor, Ellis, I mean, I think I'm not suggesting these cases don't speak to this type of situation. What I suggest is they don't say anything that wasn't available then. In 2014, Mr. Morris could have argued that the internet was central to daily life and could have cited many of the decisions that Ellis relied on to make that point. And I don't think anybody would have contested that. The Supreme Court established that the First Amendment applies to internet restrictions in ACLU versus Reno, if not before, and that was 1997.
Right. I understand, but I'm now with the benefit of Ellis, where Judge Gregory says, given the breadth of such a condition, total internet ban, and the vast liberty it deprives, it will rarely be the least restrictive alternative. Isn't that a new legal statement for purposes of precedent in this circuit? That an internet ban, a general ban, will rarely survive as the least restrictive alternative. That's pretty directly applicable here, isn't it?
It is, Your Honor, but I don't think that is something, there's a couple things I guess I'd like to say about that. One is I don't think it's something that the defense couldn't have said in 2014, perhaps accurately. It's a big thing to take away someone's internet access. I believe Judge Gregory was not talking about facts of this case, but was talking about, or of Ellis, but of perhaps a future case. In the case of Ellis, Judge Gregory made clear, or that opinion made clear, we didn't introduce any evidence that there was any connection between the internet and the defendant's crime. And what this court has held since in Comer and in Hamilton is that there's three conditions that allow a broad restriction on the internet. One is where there's a strong connection between the internet and the defendant used it in his crime. Another is when it's part of his criminal history. And a third is where there's particular characteristics that make it appropriate. And so I think that's something that ultimately still leaves a lot of discretion to the district court. Of course, Comer upheld a social media restriction and Hamilton upheld a very similar restriction to this one on the internet, which is you can use the internet only with approval. So Ellis didn't make internet restrictions illegal.
No,
changed the law.
no, but it did suggest they need to be considered with extremely close scrutiny.
Well, extremely close scrutiny, but not scrutiny different from what the 3583 standard permits. It doesn't, what Packingham doesn't do is change that section 3583 standard. This court made that clear in Van Dorn, and this court made that clear in Comer. That standard requires close scrutiny. It requires you to have the least restrictive means to achieve the legitimate goals of supervised release. But that was the standard that was in place in 2014, and that is the standard that is in place after Packingham. And what the defendant could have done was said, look, this requires really close scrutiny. It would be taking away a lot of my liberty. I have a suspicion that the defendant didn't make that argument because he was making the argument at the same time that supervised release would protect the public. So a downward variance of more than 90 months in the prison term would be okay. And I think that's part of the reason that they didn't make that argument at the time, even though it was available. And it's also one of the reasons I think this court was cautious to impose limits and to state limits in McLeod. One of the reasons for the limitations on litigating modifications of supervised release conditions is to encourage timely challenges. When a defendant considers a challenge to a supervised release condition at sentencing, they might think, well, okay, I'm putting together an entire sentence, the prison component and the supervised release component, and those are going to work together. But on a modification motion, the defendant can do what he did here, which is I'm almost done serving my prison sentence. Let me just ask the court to focus on supervised release in isolation, because there's no risk that the court might say, well, I'm not going to impose such a downward variance because I am limited in the tools I can use to protect the public here.
You know, I'm behind you on this argument. I thought that at least in McLeod, what we were talking about was something new. And is it your position this isn't new?
That is my position, Your Honor. This isn't something new. I mean, it is certainly a new case citation. You can say the Supreme Court itself emphasized the importance of social media, which is something the Supreme Court hadn't done before. But I don't think you would have gotten any quarrel even in 2014 that social media was an important tool for daily life. That's not a new legal proposition. That might be a new factual proposition for someone who was sentenced in the mid-90s, but not for somebody who was sentenced in 2014. The other thing I would mention about Ellis is that isn't a new legal proposition that the defense relied on, or I'm sorry, that Mr. Morris relied on in his motion to the district court. And what this court did make clear in McLeod is that you look at what the movement actually presents to determine whether the district court has jurisdiction, although it didn't use the term jurisdiction, or authority to consider it. It's not a question of the court has an obligation to go look and see, well, is there anything that might have changed that I could consider here? It's incumbent upon the movement, and I understand that he's pro se, but it is incumbent upon the movement to at least identify the new circumstance that warrants the court's consideration. And I don't think I don't think the court could be said to have improperly denied it based on a legal basis that was not presented to it. I did discuss some of the other conditions that Morris challenged in my brief. I don't want to go into detail about those because I don't understand there to be any dispute at this stage about those not being, the challenges to those conditions not being based on anything new, but I'm happy to answer questions if this court has any. If this court has no further questions, I'll yield the balance of my time back to the court.
Thank you. Are you any kin to people that live in Baltimore? Mr. Enright?
To them, I worked in Baltimore for a year, but I don't.
There's a whole big Enright family.
Oh,
I think you would know about them.
Literal kin. I do not know about them.
Okay, thank you.
I hope they're nice folks.
Very nice.
Oh,
As I'm sure you are.
Your Honors, I'll be very brief. I have a couple of points that I'd like to make. The first is that having an argument available to a defendant is one thing, and having a meritorious Supreme Court case to put in your brief is another. And I think that that's a key distinction here, is that you've actually got a tangible court case that you can cite to in support of your motion. And that's why it is a changed legal circumstance for Mr. Morris when Packing came out. The other point that I'd like to make is, as I try to remember back to 2014, I think there is a difference between internet use in 2014 and in the present in 2022. I can't imagine looking for a job now without having LinkedIn or some other social media profile. It is extremely important for somebody who's being released from incarceration to try to find a good job to make his life better. These are very important aspects of daily life that he's either being deprived or he's at the mercy of a probation officer to try to clear everything first before trying to go on and move on with his life. So those are the only 2 points that I wanted to make to finish off. Thank you so much. And if you have any questions, I'm happy to answer
Mr.
them.
Morris failed to raise either Ellis or Hamilton, right?
That is correct, Your Honor. And he was pro se when he filed his motion. And he filed his motion, I believe, I'll have to double check the dates here.
We decided them after he filed his informal brief.
That's right. They post-dated his motion. So hopefully with competent counsel, he'll be able to raise Ellis and Hamilton in addition to Packingham.
Thank you.
Thank you.
I guess we thank you, council, very much. Unfortunately, we can't come down and shake your hands, but we look forward to the day in which we can. And if you will excuse yourselves, then we'll have the next group of folks come in. Thank you.
Thank you, Your Honors.
We're happy to hear your argument. I'm sorry, I didn't realize we were all here. Mr. Gordon? You should certainly take it off or leave it on. Do whichever you wish.
May it please the court. Counsel, my name is Jeremy Gordon, and I represent the appellant in this case, Jonathan Malaku. Mr. Malaku was found guilty of damage to government property, as relevant here, found guilty of damage to government property and possession of a weapon in furtherance of a crime of violence. He was sentenced to 300 months in prison overall for all three of his charges. Mr. Malaku filed a motion for relief under Title 28, United States Code 2255, indicating that the damage to the government property charge no longer qualified as a crime of violence, and as such, Mr. Malaku's 924C charge could no longer stand. The district court denied that, and Mr. Malaku now appeals the ruling of that decision. In my time before the court, I will discuss how the district court erred in determining that 18 U.S.C. 1361 is a divisible statute, and how the district court erred in how using the modified categorical approach in the district court's matter. I will also discuss that the district court erred in determining that Mr. Malaku's 1361 charge was categorically a crime of violence, and as such, his 924C charge should stand. I'm going to be explaining how the district court erred in that. First of all, I'm going to explain how the district court erred in determining that 1361 was a divisible charge. It's our position that 18 U.S.C. 1361, damage to government property, sets forth alternative means of satisfying a single element rather than multiple elements which constitute different crimes. Specifically speaking, it's our position that when it comes to willfully injuring property or committing depredation against property of the United States, those things are two different means for the same element. It's our position that the plain language of the statute provides that government property can be damaged through either willful injury or depredation, and that it's a single crime with an alternative means. It's our position that willful injury is one means and willful depredation is another means. Now, the text of the statute is one way to interpret it, and the government uses ALRA to determine ways to analyze that statute. But in my time before the court, I would like to draw specific attention to the ways that 1361 has been charged and the way that appellate courts have explained through the court cases the 1361 and how that shows that it should be deemed to be an indivisible statute. We look at the actual practice from other jurisdictions in recent years, and those explain to us that 1361 is an example of a statute that sets forth alternate means of committing the same crime of destruction of government property. When we look at the Krause case that we referenced in our brief, the Krause case indicated that the defendant damaged property, that property belonged to the United States, that the defendant acted willfully. When we look at the Seaman case that we referenced in our brief, it indicates that the charging items were that the defendant willfully injured or committed a depredation, 2, against the property, 3, of the United States, and 4, that the value of the property exceeded that of the statute. And in the Justice case, the allegations were that the defendant, 1, willfully, 2, injured or committed any depredation against, 3, the property of the United States, and 4, that it exceeded the amount of $1,000. Several of the courts that we've indicated, and including the ones that we reference of page 4 of our reply brief, indicate that there was used a blanket term of destruction of government property. Not that it was willfully injuring or willfully depredation or willfully engaging in depredation, but they used a blanket term of destruction of government property. There is an inconsistent and non-uniform process by which people get charged with and convicted of 1361 crimes. And how the case is charged and how the cases are charged lend itself to it being indivisible. It's our position that there were several situations where a person was being charged with solely with destruction of government property. And in our brief, in some situations, the indictment pled both injury and depredation in the conjunctive. In the district court, in this case, the district court indicated that the or meant that it was in the disjunctive. But in the charging practice around the country, we see that in some situations, they're being charged with injury and depredation in the conjunctive.
Okay, Mr. Gordon, let's say we agree with you. The district court went off the rails at the outset by relying on the disjunctive to say these were two different crimes. Then we've got to confront, don't we, what constitutes violent force against property. It seems to me that that's the really difficult part of this case, because if we do get to the point where we have to define that, first of all, tell me your position. Do we have to define what is violent force against property if we agree with your position that the trial court jumped the track in the beginning with its disjunctive analysis?
Your Honor, it would be my position that this court should find Bowen to be instructive. And in the Bowen case, the 10th Circuit indicated that it would be very difficult to determine that there was inherent violence in crimes that were solely against property. And I don't mean to cut you off, but it seems to me the 10th Circuit stopped short in Bowen, didn't it, of actually defining willful injury to property and simply said it can't be every injury to property. I noticed that.
And then they used the spray painting example. And so are you advocating then that we do a Bowen-like analysis in dealing with that issue of what constitutes injury to property?
Well, Your Honor, I would specifically say that in this situation, that I would ask that the court find that this is not a crime of violence, and that this situation cannot, based on this law, that's in 1361, that this cannot result in a crime, that this cannot result in a crime of violence. If the court were to try to determine when is a crime of violence against property, as defined in 924C3A, it would be our position that if the court were going to do that, I would ask that the court look at, if the court were going to make a bright line rule, I would ask that the court look at whether or not, what is the ultimate object and what is the ultimate goal of the thing? All right, so in the Bowen case, we see that property, that intimidation with regards to injury was a crime of violence, but intimidation with regards to property was not. And that's because we treat property in many situations, and I would ask in this situation, that we treat property different from people. If the ultimate goal, when you look at the statute, if the ultimate goal is not necessarily tied to a person, then that would be, then it's my position and our position that would be the dividing line. So when we look at how
it's never a crime of violence when it involves property in your position, right?
Well, Your Honor, when we
just told us they were different. We treat property and people differently. So does that mean that you can never commit a crime of violence when you are doing injury to property?
I would not go so far as to say never, Your Honor. I would not go.
You say? Let's say, let me throw in an example for Judge Motz's question, if I could. Let's just say that in a government facility, they have, I don't know what the proper term is, but dogs to assist the patients in a mental health facility. And somebody comes in and tortures the dog. Well, a dog is property, right? Are you saying that could be and the dog was worth far more than $1,000. So are you saying that the dog could not be, the torturing of the dog would not be a crime of violence because it was a crime against property?
Your Honor, I would with regards to 924C. So the ultimate thing that we're getting at here is all of it in the context of a 924C crime. It's not my position today to say that that's not a crime. That if you go into a VA and you torture a dog that belongs to the government, that in and of itself is not a crime. But what I'm saying is, if a person did that and at the same time carried a handgun pursuant to 924C3, that would not be an appropriate 924C crime because it would not be an appropriate crime of violence. Because ultimately, there's not a person tied to it. It's solely and completely with regards to property.
Yeah, but it seems to me that in Bowen, and then I promise I'll cease and desist here. It seems to me in Bowen, the 10th Circuit was saying, well, we don't have to define the universe of a crime of violence, violent force against property. What all we have to do is identify acts that would constitute felonies under 1361 and say they plainly do not involve the use of violent force. And then they use the spray painting example. Are you saying that's the best route for us to go here or not? That's what I'm trying to get at.
It would be my position, Your Honor, that as far as a big overarching right line rule, as far as me personally, and as far as me and as my job on this case, I'm here to say that, and that this situation against this person is against Mr. Malaku, that this is not a crime of violence. As far if the court decides let's try to define it, then I would ultimately submit that we ultimately look at where is this going? Is this tied to a person? With regards to a Hobbs Act robbery, if you damage property with regards to a Hobbs Act robbery, that's different because because it's tied to a person. You're engaging in the damage to the property, and ultimately the goal is to get to a person. But when we talk about categorically speaking, when it comes to solely damage against property and property alone, where there's not a person that's attached to it. Like for instance, if I were to scribble on the seal of the Fourth Circuit, and that's the underlying crime underneath that of government damage to government property in and of itself, where it's not listed that it's tied to a person, it's our position that that would not be a crime of violence pursuant to 924C3B.
But I don't understand that argument, because the statute says, or the elements clause defines a crime of violence as a felony that has as an element the use, attempted use, or threatened use of physical force against the person or property of another. So it's your position that if you use force against property, it's never a crime of violence. But we know that it is.
My position is that we look at the underlying statute that in this situation, 1361, and we determine when we look at the simplest and most innocent way to commit the underlying statute, because as we know.
Mr. Gordon, can I ask you, so with respect to the statute, the government makes this argument in terms of divisibility, but the statute divides the penalties according to the dollar value of the damage to the property. You commit damage to property of $1,000 or less, it's 1 year in prison or less. Anything over $1,000, it's, I think, 10 years. Setting aside whether or not that makes the statute divisible because of the differing penalties, what about that as a line of demarcation in terms of the crime of violence by the damage to the property?
I would submit that it's all going back to the idea of it being categorical. When we talk about categorically speaking, we talk about what is the most innocent way to do the crime. That's one way to look at the categorical approach. So when we look at the most innocent way to do the crime, then the most innocent way to engage in damage to property that is like $1,001. It's our position that part, the $1,000 line of demarcation, that in this situation, it's my position it should not factor in to whether or not.
Well, I guess what I'm suggesting is that perhaps categorically anything over $1,000 is a crime of violence. Whether or not you can commit a crime of violence and cause damage to property less than $1,000 is something that's left for another day.
It would be our position that under what we previously talked about, that the dollar amount would not come into play, because if we're starting to determine if it's under $1,000, then we'll leave it to another day. But if it's over $1,000, then it's a crime of violence. But that does not. But when we look at Bowen, and we look at Curtis Johnson, and we look at Stokely, then what is required in order to create a crime of violence, and what the guidance that those courts have given us with regards to what is a crime of violence leaves out a dollar amount. It leaves out a dollar amount because it all goes back to the idea of if it's against a person or if it's against property, and how we treat things differently when it's a person as opposed to property.
Okay, I want to do, before you sit down, your time has expired, one more try at what my colleague has asked you. I'm sure you've read a million of these cases about crimes of violence. And sometimes we define what would be a crime of violence under the statute. And sometimes we just say, this isn't a crime of violence for these various reasons. Would there be any issue with doing the latter here?
If the latter is the second one, right?
Right.
I'm so sorry. I never.
I speak in code.
I'm so sorry. Can you repeat the question? I got stuck on the line.
That's all right. So sometimes when we talk about crime of violence, we talk about the issue in front of us and we discuss whether it is or isn't a crime of violence, and we come to a resolution. And sometimes we just say, this isn't a crime of violence, and we explain the reasons why. Would there be any problem with doing that here?
I'm fine with it, Your Honor. If the court
That's
determines.
all I need to know. Okay, thank you. Now we'll hear from the government.
Apologize, Your Honor. This bag is giving me a run for my money.
What did the bag do?
I think you're committing a crime.
For the microphone.
I think you're committing a crime of violence.
That's just an ad hoc.
Good morning, Your Honors. May it please the court, Aidan Grano-Mickelson for the government. I'd like to pick up, if I could, with the court's questions to my friend on the other side. One about what this court does and does not have to decide, and then about the penalty structure. So here we are dealing with a charge of the over $1,000 amount. And under the Sixth Amendment, that becomes an element of an aggravated offense. So this court does not have to address what the offense of 1361 simpliciter means for purposes of the crime and violence. It only has to address what happens when the damage that actually results is over $1,000. Once we get into that, I think it is to the point of theoretical or legal impossibility to think of a situation in which a person intentionally commits an act designed to damage property, does so in an amount over $1,000, and has not used a quantum of force that we would consider to be violent. And I think
so let's just say somebody pours water on a computer and causes damage of over $1,000 and does so intentionally. I mean, just pours the water. That's a crime of violence, according to you.
Yes, Your Honor, because the damage done to the computer is significant. So when we think about an act of violence, we don't look at what physical effort the person exerting does when we talk about violence, because this court has already recognized in cases like Rumley that indirect or omissions count as uses of force. What the problem with a violent use of force is the intentional employment of some device to cause harm or injury. So the fact that pouring a glass of water over a computer merely requires tilting your hand doesn't dictate whether or not it's violent. What dictates whether or not it's violent is whether the force employed, the water, is being used against an object, the computer, in a way that's likely to cause a harm or injury.
So every injury to government property under 1361 that is willfully done and results in $1,000 worth of damage is automatically violent.
Yes, Your Honor.
Force against property.
Yes, Your Honor.
Well, aren't you reading the word violent out of the analysis then? Why isn't it simply enough to have injury to property?
I think Stokeling is the right lens to use.
Yeah, but
for this
Stokeling was
question.
robbery. It was a crime against the person. I mean, I think you've got to do a little better than that.
Yes, Your Honor, but I'd like to point the court to page 554 of Stokeling, where the court is talking about why it's refusing to use the adjectives like severe or substantial when it's talking about the use of force that's involved there. The court specifically rejects the idea that we look at the probability or likelihood that it's going to result in significant damages and says, instead, crimes can be committed in many different ways, and it would be difficult to assess whether a crime is categorically likely to harm the victim, especially when the statute at issue lacks fine-tuned gradations of force. We decline to impose yet another indeterminable line-drawing exercise on the lower courts. Stokeling was very clear that at the point at which force crosses the threshold into capable of causing harm or injury, it becomes violent. And they cited specifically Justice Scalia's concurrence from Johnson, which talked about things like hair pulling,
right, and Johnson
and
was also talking about injury to person. And it seems to me you're using a template that is different, and you're not explaining. You're just wishing that it works, and you've got to show us. It seems to me, and that's why I'm really interested in hearing you, why you aren't just reading the concept of violence out of the definition, because if every willful injury to government property of more than 1,000 is violent, then why do we even have to think about violence? And where is the basis for that? If we reject that Stokeling and Curtis Johnson, they were talking about people and harms to people. Where do you get, how do you write this opinion?
Sure.
In your favor, I guess is what I'm trying, I'm
Sure.
trying to figure out.
Sure, Judge Keenan. I think maybe this is where it's helpful to talk about what's not covered by violence and threats to property or injuries to property. If the actual force employed or the action employed does not injure or damage the property in any way, but merely defaces it or disrespects it or something, that would not fall within the meaning of the quantum of force that we would require for violence.
Well, okay, I have a question to ask you about that. Suppose you spray painted the whole building gold. Now, we know spray painting doesn't count, isn't violent necessarily, usually, but here he's done more than $1,000 or $10,000 worth of damage. And I thought under your earlier argument, that would constitute a crime of violence by definition, as far as you're concerned.
Your Honor, I think the challenge there is whether or not it actually falls into willful injuring, not the quantum of damage.
Oh yeah, no, it's the guy that he wants to injure the building. He wants to make his point. First he does his initials and then he just decides to do the whole building.
And I think at that point, when you've crossed over into doing that amount of what we consider to be damage to property, you've crossed a threshold from nonviolent acts of force into violent acts of force. There's no other real principled way to determine where the quantum of force falls when it comes to property. And that's exactly the point that Stokely was making in relation to offenses against the person, is we don't engage in an analysis of how much the person would be hurt. Similarly here, once something has injured property, that's the threshold. So Judge Keenan, maybe
but I think that you can make an argument, at least, although it's been rejected by the courts, that spray painting the building at all injures the property.
Your Honor, and I think that is a harder question, but not where it does over $1,000 worth of damage. So I think Hill, for example, the Second Circuit.
No, go ahead.
In Hill, for example, the Second Circuit made the point that it's not the pressing down of the button. This is the point Judge McHugh made in dissent in Bowen. It's not the force of pressing down the spray can lever to deploy the paint. It is the act of using something to damage the object, the property.
So, when Congress passed this statute, the damage to property statute, it obviously wasn't thinking about its application in the 924C context. So it's just a happy accident, I guess, that we have this demarcation in terms of damage. But if we didn't have that, then what would be the principled way to distinguish the offense for purposes of the force clause in 924C? Is there another way besides that?
Your Honor, I think, for example, if we took a hypothetical statute that doesn't have the word injure in it, so you could violate it without actually injuring or damaging property, I don't think that would fall within 924C's
but why
force
don't you
clause.
deal with the hypothetical you were given, which is a statute that doesn't have amount?
Yes, Your Honor. And so I think that's the demarcation, is if there's no penalty division in the willful injury statute, the willful injury statute becomes a crime of violence because you are damaging property. And the quantum of force for property crime is that which is capable of damaging property.
So if you just spray painted a little circle like this, that would injure the property and that would be a crime of violence.
Yes, Your Honor. If it goes through willful injury, if you get to willful injury.
Well,
then,
you willfully did it for sure. And it's injury and that the government's going to have to repaint it.
And
But
I think
if it doesn't cause, if it causes $900 worth of damage, then you're saying it's not a crime of violence, painting that little circle, $900 to get it off. That's not a crime of violence. But if the circle just is extended a half an inch and it takes $1,000 to get it off, then it is a crime of violence. Now, where is the sense in that?
No, Your Honor. Actually, I think my point is that once you injure property and you've committed damage to property, that's the crime of violence, not the $1,000 mark. This court doesn't
Well, it
have
has to be a felony, though, to qualify as violent force against property, doesn't it?
Yes, Your Honor. And I think that's
Okay.
where this court doesn't have to analyze the lower end of the spectrum to determine whether or not injury amounting to less than $1,000 counts.
Let me
Because
ask you another question, if I could, and then I'll try to cease and desist. It's I think we're straying away from the categorical approach and the purpose of the categorical approach. I'm worried that we are. Purpose of the categorical approach is really to see if this person could have committed the crime and in a way that was not violent. In other words, can a person violate this statute in a way that's not violent? And if there is a way that the statute plainly can be violated, then doesn't that end it We don't have to define
Yes, Your Honor. If the court
violent
concludes
force
that there is a
against
way,
property. Mhm.
yes, Your Honor. If the court concludes that there is a way in which the above $1,000 threshold can be committed without violence.
And if let's just say we don't accept, or we have difficulty accepting your saying that tilting your hand to pour water on the computer is a crime of violence if the damage is $1,000, but tilting your hand to pour water on the computer is not violent force against property if the damage is $999. Again, how do you write that? How do you write an opinion that says if there's $1 worth of difference between damage to property, that makes it a violent force against property, but if it's $999, it is not violent force against property?
Sure. So, Your Honor,
some logic, not just sticking to the position that you're giving us, but the logic behind it.
Yes, Your Honor. I think if the court were to write an opinion that talked about the quantum of force necessary to commit a crime of violence against property, the line the court should adopt is force capable of causing harm or injury to property, which mirrors the standard in Stokeling. That's how I would write it. If the court was uncomfortable with doing that in all cases, the court could adopt a shorter, more restrained reading that says, when looking at the set of hypothetical cases in which a person willfully injures property to the tune of $1,000, we have a hard time coming up with a scenario in which that happens with nonviolent force. The court does this with aggravating penalty structures all the time. It was done at Bryant. Allred talked about aggravated penalty structures. Runyon dealt with a conspiracy for murder for hire, which categorically would not be a crime of violence, except the death resulted. And the court said, we have a hard time envisioning a situation where people enter into a conspiracy to kill someone, intend to kill them, and the death of that person results, and it somehow didn't involve violent force. The court could adopt, if it's uncomfortable with the low end of the spectrum, that analysis here and leave for another day what happens with injuries to property that are not so severe to cross the $1,000.
So, and I don't mean to attempt to answer the question that Judge Keenan posed to you, because obviously you're doing a fine job responding to questions, but and I get the concern about sort of the arbitrariness of the distinction that we're making, but the statute itself, 1361 is every bit as arbitrary. I mean, if you damage property to the tune of $1,001, you're on the hook for 10 years. If you damage property and only costs $1,000 worth of damage, at that point, it's a 1-year felony. So it doesn't seem to me that it'd be any less arbitrary for us to make the distinction that we're making here, that you're proposing for 924C.
Your Honor, and just to follow up on that point, which I think is very well made, that Congress drew a line here essentially saying over certain quantums of damage are more serious crimes. And I don't think it's inconsistent with the purposes of 924C, which aggravate penalties when someone uses a firearm to commit a particular quantum of damage, for example, in this case. I don't think that's inconsistent.
Fine answer. And the hypothetical the question was excellent. But your earlier position, I thought, was that any damage of property is a crime of violence.
Any damage willfully caused is a crime of violence.
Right.
Yes, Your Honor.
Even if it only costs $500 or $50.
Yes, Your Honor. And I think that.
So, what about attempts? How do you deal with attempts? Because under this statute, 1361, an attempt to injure property, an attempt to pour the water on the computer, I start to do it, and then all of a sudden I sneeze and I don't do it, okay? But I intended to do it, and I was trying to do it. I brought the water. I had one act that was necessary to the completion of the crime. That's a crime of violence too?
Yes,
holding the water over the computer as I sneezed?
Yes, Your Honor, because 924C3 includes attempted uses of force, right? And an attempt requires the specific intent to use the force that you would.
And I did. I wanted to pour the water, but then I sneezed. And then I realized, oh my gosh, this is a stupid idea. But when I started to pour or started to tilt the glass, I intended to do it. That's a violent force against property under your analysis.
It is an attempted use of force, which makes it a crime of violence under 924C.
Assuming it gets prosecuted.
Assuming it gets prosecuted, Your Honor, yes. And I do think that it is a useful point to make in this context. Runyon made this point, Roof made this point, Allred made this point, that we deal with legal realities when we're doing the categorical approach. We don't accept hypothetical or legal impossibilities.
Right,
as ways
but
to
the person
undercut
in
statute.
Idaho was, I mean, people do prosecute these crimes, even though perhaps these crimes are prosecuted.
Yes, Your Honor, but I think, again, the only line that makes sense and is consistent with the Supreme Court's discussion of what violent means in this context is force that's capable of causing injury to property. Now, the actual physical force that's used differs because humans are susceptible to different forces than a stone monument or a federal building, for example. So the actual application of the force may be different. But the only standard that makes sense and is a principled bright line to use in this context is the one from Stokeling, force capable of causing harm or injury.
What about Mr. Gordon's theory? I thought that was kind of interesting. He was saying that, really the Congress was, it seems more likely the Congress was getting to the situation where a person could be hurt, such as arson or shooting into an occupied building or something like that, where the property was injured, but that wasn't the gravamen of the offense. It was inherently violent because of the danger to human life. How do you answer that?
Your Honor, my answer to that is the same question that Judge Motz asked my friend on the other side. It's that 924C includes uses of force against a person or property. It does not only limit it to use as a person. And in fact, shooting it into an occupied building, this court has said, does not fall within the Armed Career Criminal Act, which does not include a property variation in its elements clause. So we know in passing 924C that Congress was intending to capture some property, at least some property crimes. But the Supreme Court's decision in Stokeling says we don't try to draw a quantum of forces once something crosses over into the realm of being capable of causing harm or injury.
See, my problem, you probably guessed it, is that under your analysis, every violation of this statute, even if it causes $2 worth of damage, is a crime of violence.
Yes, Your Honor, I think that's because of the words that the statute uses for its offense elements, not because it covers things that don't injure property or don't cause damage to property. I think the government would agree that if there's a statute that included non-damaging acts, for example, the predecessor to this statute, which included larceny of federal property in it, we would have agreed that if that were the use of force or damaging any property. But in this context, when Congress took larceny and theft of government property out of the statute, it left only willful injuring and depredations of property, both of which necessarily involve violent means.
I don't know that we have, do we have more questions? No?
Thank you, Your Honors, and I'll rest on the briefs.
Thank you. Is there any rebuttal?
Your Honor, the first thing that I want to talk about is what Judge Keenan said, and that is that the categorical approach matters. When we are looking at whether or not this should be, 1361 should be a crime of violence, I do believe that we can use the categorical approach in and of itself in order to say, for this particular crime, in this particular situation, we're going to take 1361 off the board. We're going to say that 1361 is categorically not a crime of violence with regards to 924C3 purposes.
Because we already do that. Well, first of all, do it because of either the inherent nature of the inherent danger that's not present to human life, pursuant to Bowen and pursuant to Stokeling and pursuant to Curtis Johnson, and the fact that in this situation we treat property in this situation, categorically speaking, differently in how we treat people. But then the second reason would be because we do this all the time. We do this all the time with regards to conspiracy to commit Hobbs Act robbery in 924C. We do this with regards to other crimes with regards to 924C. Since Johnson and DeMaya and Davis, we've been taking these crimes off the board because we've come back to realize that they don't categorically meet what it takes in order to be a crime of violence. See, his position is that every violation of this statute categorically meets the crime of violence. That's his position. Maybe that's wrong. But in those other cases, Supreme Court cases, the government acknowledged that some things were crimes of violence.
Well, yes, Your Honor, that is his position, and that is what the Supreme Court did. But the difference is that when we use the categorical approach and we use the most innocent way to commit the offense, as we've discussed today,
Right.
it doesn't match up with the amount of the terms of violent force and inherent violence that were used it doesn't match up with regards to people, because we've all looked at the fact patterns. We've all looked at the fact patterns in and of themselves that lead to problems with regards to 1361 being a crime of violence. And to be clear, these things, 1361 will still be a crime. And if the court were to send this case back down, Mr. Malaku would still be charged with two other crimes. The sentencing package guidelines, sentencing package doctrine would still apply, and the government could still ask for the same 300 months. All we're saying is that in this particular situation, this 1361 crime is no longer a crime of violence because for the same reasons that spray painting the car in Bowen is not a crime of violence.
Right, but Bowen, and I guess what I'm trying to see is, do we need to go as far as you're suggesting? Bowen didn't go that far. It didn't totally take the statute off the table as ever being a crime of violence. You see what I'm saying? Or ever being violent force against property. It merely said, because as you were just asking us to analyze, the most innocent conduct under the statute doesn't qualify. So it seems to me that you may be asking for more than you need in order to prevail. Could you address that?
Yes, Your Honor, I can. The first thing that I want, the first thing that we're asking for, that our position is to say, without getting in regards to the overarching, without trying to define it, without getting into the overarching thing of what does it mean, a crime of violence in this situation, we're going to say that this court made the wrong decision and we're going to send this back down. We're going to say that in this particular situation, pursuant to Bowen, in this situation, this was not a crime of violence, not here, and we're going to send this one back down. That would be the first thing that I would ask. That would be the first position that I would have. If the court found it to be so appropriate, then they're trying to define over what is a crime of violence and taking 1361 off the board, totally speaking. Those could be the things that the court could do. But as for me, and as for right now, in this situation, and as for Mr. Malaku, we'd ask that the court just send it back down.
Does our resolution of this case have any effect on your client at all?
Well, Your Honor, it would matter with regards to how he is sentenced, because with a 924C, he would have certain problems with regards to getting into certain classes. If he wanted to do the residential drug abuse program, he wouldn't be able to do that with 924C. How he gets in his classification inside the walls of the prison.
But not with the term.
Well, Your Honor, he could go back down to the district court and get sentenced to 300 months again. That definitely could be true. And our office has done an amount of post 924C3 litigation and post Davis litigation, and sometimes that does happen. They go back down to the district court, and the district court says, "I said what I said," and it gives them the same thing that they had previously. That could be, but it's still our position. But in other situations, the court could look at the Pepper resentencing factors and determine this person has made changes since they've been sentenced originally. So I'm actually going to give them a reduced sentence or the circumstances of prison.
Do we have more questions? No. Thank you very much. Would you like a break? Well, we thank the lawyers for their argument. We're sorry that we can't come down and shake hands with you. We hope the next time you're here, we can do that. Stay safe and thank you again. And then maybe you'll send in your colleagues in the next case. Thank you.
Yes, Your Honor. Thank you.
May it please the court. My name is Christian Preuss. I represent the appellant, Church Mutual Insurance Company. In this insurance coverage case, this court is presented with applying the phrase caused by in the insuring agreement of a liability insurance policy. The insuring agreement, of course, defines the scope of coverage. That's where we begin in determining what coverage.
Talk up a little louder. Thank you.
I'm sorry. The insuring agreement, of course, defines the scope of coverage. That's where we begin to determine whether a claim is covered or not covered under the insurance policy. Every insuring agreement will have multiple requirements that must be satisfied to fall within the insuring agreement. The clause caused by is a very frequently used clause in a liability insurance policy. It's standard in a general liability policy, whether on a commercial line and across all industries. It's standard in a homeowner's policy, often an umbrella or excess policy. And it's actually very frequent also in an auto policy. In this particular case, we're dealing with a professional liability coverage that uses the clause caused by in the insuring agreement. There's no reason that clause should be interpreted or applied any different in this case than in any of the other cases where the insuring agreement uses that clause. The underlying Fourth Amendment complaint in the underlying lawsuit has a claim for breach of contract. And that claim for breach of contract alleges that the plaintiffs are all residents of a care facility and they paid for certain services. They did not receive the services they paid for and they want their money back. That's basically the claim in the underlying lawsuit. There are also allegations that Lake Point, the named insured and those that managed it, the Biglers, had a business practice designed to maximize profits in which they deliberately decided they would not hire people necessary and do other things necessary to provide the services for the residents. These were management and operation decisions that permeated their entire business plan. The breach of contract claim in the complaint has the standard elements for breach of contract. Paragraph 36 lists the promises that were broken. Paragraph 37 states this is a material breach of contract. And then paragraph 38 alleges solely economic damages and alleges that the plaintiffs did not receive the identified living services they paid for. So they want their money back. The focus on the coverage issue is on the definition, in part on professional healthcare incident. There's one clause in there that is included in the definition that provides that the definition includes failure to comply with the right of a resident under any state or federal law regulating you being the named insured, as a resident healthcare facility. It does not define professional healthcare incident as failure to comply with a contractual obligation. The underlying Fourth Amendment amended complaint, which advances only a breach of contract claim in addition to a UTPA claim and the claim against the Biglers individually, does not advance a claim for failure to provide any right of a resident under state or federal law. It alleges.
Well, the residents here alleged that Lake Point breached a contractual promise to comply with state regulations, right? I mean, there's no question about that.
Correct. That the contract implicitly incorporated the administrative code provisions for licensing of healthcare. The point.
Well, doesn't that mean that the injury was caused by a failure to comply with state law?
The way you phrased it, perhaps, but this is with the right of a resident under any state or federal law. It does not apply to any violation of federal or state law. The regulations that they've cited in the complaint, number one, and there are two parts to this. Number one, it's part of the administrative code that is a licensing requirement. It's not a right granted to the residents. There are separate statutory rights expressly granting the residents their rights. That is not alleged in their complaint.
Right, but what Judge Motz is saying is there's overlap. And it sounds to me like you're not denying there's overlap. These are rights that the contract assured, but were rights that were also guaranteed under state or federal law. Am I misunderstanding?
There's a step there that I think needs to be taken.
Okay.
The contracts incorporate provisions under the licensing administrative code, and the contract, at least alleged in the Fourth Amendment complaint, states that you have agreed to provide us services, and those services are services also included in the administrative code, and you must provide those. So in that way, the contract wraps in the administrative code. And my point is twofold. Number one, they're alleging the violation of administrative code. They're alleging a failure to comply with state laws, but they're not alleging failure to comply with the right of a resident under the state administrative code. They're alleging failure to comply with a contract. And so it does not qualify as a professional health care incident. But even if it does, even if you say, well, that's close enough, we're going to say this is a professional health care incident, then it gets back to what is meant by caused by. And that's where getting into the case law that we've cited, and I want to maybe highlight a couple of them, becomes important because it's different than arising out of. This court addressed a pretty similar scenario in the Affinity Living versus Starstone case. And in that case, that was a False Claims Act claim involving a resident facility. Similar, a False Claim Act is different than a breach of contract, but the underlying factual circumstances were the same. And that is that the facility charged for services it did not provide. And in that case, Medicaid was billed and Medicaid was overbilled. And the claim is to give the money back because Medicaid is overbilled. And in that case, the insurer argued that there's no coverage because it doesn't fall within the insuring agreement. And this court's decision the district court and then this court also in the discussion discusses that the claim is not seeking damages for failure to promote professional services. Billing is not a medical incident, similar to breach of contract is not a healthcare incident in this case. But then this court went on and said, but we're dealing with the phrase arising out. Arising out of is much broader than caused by. And it cited the state capital versus nationwide decision, which is a North Carolina Supreme Court decision, emphasizing that when the phrase caused by is used, it's much narrower than arising out of.
Okay, but why can't injury be monetary? I mean, the policy doesn't limit injury to bodily injury.
No.
So if I don't get meals that I should be getting, nutritious meals, I'm suffering a monetary injury caused by your failure to provide them as guaranteed under state or federal law.
But the claim being asserted is for the breach of the contract that incorporates
right
the state resolution.
And I'm saying I've suffered a monetary damage. I'm not saying I'm more weak or infirm or anything, because this policy doesn't limit. I mean, I think it's really curious that the policy doesn't limit injury to bodily injury or physical injury, but it doesn't. So why wouldn't monetary injury meet the caused by requirement of the policy definition?
The caused by, it's the injury caused by the professional healthcare incident.
Right.
And
And the professional healthcare incident is not giving nutritious meals.
but that not giving nutritious meals breaches the contract. It's one step removed. The contract is the claim that's asserted here, as opposed to a claim for damages or any other relief caused by failure or violation of a professional health care incident.
What do the state regulations say about these facilities?
The state regulations and the ones cited in the administrative code in the complaint are licensing requirements, as opposed to any type of direct right of a resident.
I understand that,
And
but what do they say about food, for example?
There's a certain minimal food price that must be paid for food that must be provided to the residents.
Does it say anything about nutrition?
There, in the licensing requirements, I think it all goes to nutrition. It's relating to nutrition, but again, those are licensing requirements. There are separate statutory requirements that list the rights of the residents, and that would be the basis for the resident to assert a claim for a right under a state or federal law. They haven't cited any of the statutory provisions that grant the rights. They've only cited the administrative code. The statutory provisions also provide for a private cause of action. So they have the ability to assert a private cause of action alleging violation of rights under state law. That is what they have not done. Instead, they've simply alleged breach of contract and seeking to have the money they paid returned to them, as opposed to a damage that flows directly from the violation of a right under a state or federal law. It's North Carolina statute 131D-21 or 28-21 that lists the rights of a resident under state law, under the statute. That lists the rights. And then it's 131D-28 that gives the private cause of action.
So when you're quoting to me in the contract that the resident has with Lake Point Assisted Living about specific state laws, I thought it said that you had to be in compliance with state requirements. Or does it say have to be in compliance with these specific state requirements? Is that what you're saying to us?
No, it has to be failure to comply with the right of a resident under state or federal.
It actually says any right of a resident
Right.
under any state or federal law.
I
It's
don't
quite
understand.
broad.
I don't understand where you're getting your distinction here.
It's not simply the violation of a state or federal law. It's the violation of, or the failure to comply with any right of a resident. The provisions they've cited are not dealing with the right of a resident. They're licensing requirements that they then incorporate into the contract. So it's one step removed. And for that reason, when you're looking at the phrase caused by instead of arising out of, which has a proximate cause meaning to it, a direct liability meaning to it, instead of the broad arising out of that was addressed in the affinity living case, it reaches a different conclusion. And that's emphasized by footnote 12 in the affinity living case, which specifically contrasts arising out of with caused by. It cites a 10th Circuit decision that comes to the opposite conclusion when the insuring agreement uses the phrase caused by instead of arising out of. And that is analysis would be the same here. If the policy language said arising out of, then if there's any violation out there that's been alleged, then this arises out of that overall factual circumstance. Then it would satisfy the insuring agreement, just like in the affinity living case. But when the phrase caused by is used, and the only claim is a contract claim, it must be directly flowing from the contract claim, not the overall factual circumstances that are alleged in the complaint. I see
Your time has expired. Yes,
Right.
thank you. Coates?
Thank you, Your Honor. May it please the court, my name is David Coates. I represent the defendants, Lake Point Assisted Living, Edith Bigler and Tony Bigler. To my right is David Stradley, who represents the resident defendants. I'll be making the entire argument today. And Your Honor, I think it's relatively straightforward. There are only 4 rules of construction in North Carolina insurance contract law, which are really germane to this. The Stocks case, all provisions in insurance policies which extend coverage to the insurer must be construed liberally to afford coverage whenever by reasonable construction. 2, the words used in the policy have been selected by the insurance company. Any ambiguity or uncertainty as to their meaning must be resolved in favor of the policyholder and against the company. 3, where no definition of the term, and this is what the district court and when Judge Myers goes into the definition of injury and goes to Blacks in Oxford, this is what he really relies on, where no definition of the term is contained in the policy, unambiguous terms be given the meaning afforded them in ordinary speech unless the context indicates that another meaning was intended. 4, when a term is ambiguous and that it's susceptible to several reasonable definitions, the rule is that doubt as to which definition to accept will be resolved against the insurance company and in favor of the insured. The plaintiff is not contending that there's any policy exclusion that applies. The plaintiff is not contending that there is breach of any policy conditions. They're only contending that the liability insuring agreement is not triggered, and therefore they have absolutely no defense obligation and no indemnification obligation. And as Your Honor's already pointed out, there are 3 very specific policy issues using the policy language that are pertinent to the inquiry. The insuring agreement is the only issue here, Your Honor. That the plaintiff will pay those sums that the insured becomes legally obligated to pay because of damages because of injury. Injury is not defined by the plaintiff. 2, this insurance applies to injury only if the injury is caused by a professional healthcare incident. And 3, professional healthcare incident means failure to comply with any right of a resident under any state or federal law regulating you as a resident healthcare facility. The plaintiff does not take issue with the district court's finding that Lake Point is a resident healthcare facility.
No, but they do take issue with the last, at least I ascertained, maybe I misunderstood, that the third element that you're talking about, they say that that isn't the right of the resident to rely on these state regulations. Maybe you can speak to that.
Yeah, and I think, Your Honor, that Fourth Amendment complaint in the class action is replete with allegations of there have been these violations of state law and regulations, including the patient's Bill of Rights. And so no one else has standing to assert those claims other than the residents, and that's precisely what they're doing. And the allegations are replete in that complaint that there have been violations of these state laws and regulations, which has caused them injury.
But his point, I think, is that the residents don't have any rights to enforce those state regulations. I think that's what he's saying.
I am not familiar with any case that would ever say that that is the law, because I think it's like you have, it's a leap of faith to sit there and say that there are violations, they're alleged to be violations of state laws and regulations pertaining to these residents. And they cite that in their complaint as part of their claims that those rights have been violated, and then to say they don't have standing to bring those claims. I don't see,
because they only regulate the institution, your client.
And I think the patient's Bill of Rights within the statute under 131D pertains only to their rights, and their allegations that those rights have been violated. I'm not sure how you can back off of your definition of professional healthcare incident and say that has no application in this case because the residents somehow don't have the right to bring the claims that they brought. And you look at the four corners of that complaint and the four corners of the policy, and within those 8 corners, that's what they're claiming. If you're saying that somehow in the underlying class action, there might be summary judgment down the line with respect to those issues, that's one thing. That's not what we have here, looking at those 4 corners and those 4 corners. Those are the claims they've alleged. This is what the policy has about professional healthcare incident.
So you think this argument of theirs, if it has merit, is an argument to dismiss or to grant summary judgment or something?
In the
Is
class
that what
action,
you're saying?
Yes, Your Honor, in the class action, because they're there. That's what's been alleged. The 4 corners of the complaint, the 4 corners of the policy, the allegations are our claims are that we have standing to, we have the right to bring claims for violations of the patient Bill of Rights under Chapter 131D. And that's the claims. The policy says professional healthcare incident is violations of any state or federal laws or regulations. I mean, they marry up completely. And so, and there's no assertion that Edith and Tony Bigler, my other 2 clients, are not insureds. And again, the 4th amended complaint, the 3rd claim for relief, are negligence claims against the Biglers. And my folks are insureds. And so how can the plaintiff argue that, and their allegations are that the Biglers were negligent and they had a duty to exercise reasonable care in the care, management, and operation of the facility, and that they breached that duty by failure to comply with those state regulations. The staffing requirements, 10 NCAC 13F, the nutritious meal requirements, 10 NCA 13F 0904, the activities requirement, the planned group activities requirement, 10 NCAC 13F 0905, the failure to comply with the patient Bill of Rights, 10A 13F, and the 31D statute. Again, how can plaintiffs say, well, everything's arising out of a breach of contract, and so the policy wasn't intended to, we didn't define damages such that it excluded breach of contract claims. Even if that was the case, their claims against the Biglers sounded in court, which are not premised on a breach of contract. So I'm not sure I understand that. That's a leap of faith, I think, that Your Honors, the court should not make. Yes, sir.
So I guess the problem I'm having, and I think Judge Myers, I guess, acknowledged this issue when he dismissed the claims under A1 of the policy for any act, error, omissions, or failures in the furnishing of professional health services, because at bottom, this is a professional liability policy, and it seems odd to then say, on the one hand, that I'm dismissing these claims because there's no professional judgment that was part of the furnishing of food, beverages, medications, et cetera. But on the other hand, say it nonetheless satisfies the requirements of the policy because of a violation of a regulation for those very same acts. Does that make sense?
It is, and I think that's to Judge Keenan's point about why did you draft it like that? Our folks had no involvement in the drafting of that insurance contract. The people in the underwriting department in Wisconsin drafted that contract. We had no input on it, and that's how they defined it. And so that's why I think Judge Myers goes into, yeah, we have affinity, which found coverage. And I think Judge Myers, if you read the opinion, says that seemed to be a pretty tenuous thing between, it's not professional healthcare incidents, like professional medical incident, between false and fraudulent Medicaid claims equates with a professional medical incident. He said, we don't need that here, because for some reason, the plaintiff has chosen to say a professional healthcare incident equates with failure to comply with any right of a resident under state or federal law. And I think to Judge Keenan's point, it is curious. I'm not sure why they did it. We'll never understand why they did it, but they did it. And I think they have to take ownership of how they define that in the insurance agreement. I'm not sure how they escaped that. You look puzzled, Judge Diaz. Okay.
Well, you're not unhappy about it, I know.
No, sir. No, sir. No, sir. And again, and I think the plaintiff's contention that damages caused by a breach of contract are not damages caused by a professional healthcare incident. And that's why I think Judge Myers said, you have your insurance agreement and that's how you define it. So it's not like affinity where we have to have some gymnastics to get to that point. This is what you say. And so when the district court says that the failure to comply with North Carolina regulations governing adult care homes, quote, falls squarely within the scope of the insurance policy's broad, unambiguous language that a professional healthcare incident can stem from violations of any right of a resident under state or federal law. And so affinity, which again found coverage, I'm not sure really has any application. I embrace it because it found coverage for false and fraudulent Medicaid billing. And somehow that's a professional medical incident. But we don't need that here. And the district court didn't find that you needed that here because you have this extraordinarily broad insuring agreement that the plaintiff drafted. And so, for example, I'm not sure how the plaintiff quotes extensively about the Zurich case from the Fifth Circuit. Again, insurance law, state law. I think that was Colorado law. And I'm not sure how Zurich has any application because they indicated in that case, I think it was the Zurich policy, they said that false and fraudulent Medicaid billing did not arise out of a medical incident. In essence, they said under, I think it's the Zurich policy, they had three policies there, that in essence, they came to the exact opposite conclusion under that policy as the affinity case applying North Carolina law. So I'm not sure how and I think Judge Myers is correct, how do you get it's caused by a professional healthcare incident as you defined it? The allegations in the complaint are replete with that. And so I don't think Zurich or those cases, and a lot of these things, it's like, and it's like how you define injury. A lot of the insurance coverage cases cited by the plaintiff, American Reliable, Western World, Westfield, they pertain to like commercial general liability policies, which are different animals. Because they say the insurance agreement is triggered for bodily injury, which they define as physical harm, bodily harm, sickness, disease, or resulting death caused by an occurrence, an accident. They have, and there's all sorts of case law about that. Those policies define property damage in the insuring agreement as meaning physical damage to tangible property caused by an occurrence, an accident. We don't have that here.
Mr. Coates, you mentioned that you say that these allegations make out both a breach of contract and a tort, I guess, with respect to the owners of the nursing facility. But under your view of this case and the policy, do you need a tort claim for coverage? I mean, a breach of contract would be covered under your view of the policy, right?
Yes, sir. Yes, sir. Because they never defined it. They could have defined injury to say, they could have defined damages. Damages don't include damages arising out of a breach of contract. They didn't do that. They could have said damages don't include economic damages. They didn't do that. Injury, damages, not defined. Professional healthcare incident, very, very broadly defined. I'm not sure how you escape exactly what the district court did. This is what their policy that they wrote under the rules of construction. There's absolutely a duty to defend my clients based upon there being a professional healthcare incident. And again, there's no exclusions whatsoever. There's no breach of conditions. There's none of that. We just have allegations about time after time after time. These allegations that these state laws and regulations were violated, which caused damages to these plaintiffs. It falls squarely within the insuring agreement that they drafted. There's no exclusion. It's just a trigger of coverage in that insuring agreement, and they have to have ownership of how they define professional healthcare incident. And I think, honestly, Judge Myers, if you read the opinion, he wasn't surprised, per se, by how they defined it, but he said, Affinity is not close to being this. Again, Affinity found coverage, but it's like, we have a very definitive policy language here. We don't have to get to false and fraudulent Medicaid billing being a professional healthcare incident. We have violations of state or federal law which caused injury or damages to the plaintiff, period. That's how you defined it. That's exactly what the residents alleged. I'm not sure.
The argument on the other side, I think, seems to be that the residents don't have any right to rely on these violations of state and federal law. Maybe I've misunderstood. And I think you talked about that earlier. Maybe it's a standing argument. I'm not exactly sure what it is, but I think that's the argument. Maybe because of the way the policy is written.
And I'm going to say there's a twofold argument there, and I'm going to try to think of the second one in a second. But the first argument is that the 131D North Carolina General Statute speaks to the patient's Bill of Rights. That's alleged in the Fourth Amendment complaint in the class action. No one has standing or an ability to use that as a launch for a claim other than the residents. And the four corners of that Fourth Amendment complaint in class action says, we were injured and we were damaged by the failure to comply with that statute and the failure to comply with these other administrative code statutes about nutritious meals, planned activities, grouped activities. We're injured by that. And so, yes, ma'am.
So the patient's Bill of Rights has specific things about food and...
It's like a laundry list of 12 or 15 things. I remember Judge Myers quoted to 131D, 121.2 in particular, but it is their rights. Okay. And again, the four corners, Your Honor, if that's the plaintiff's claim in the class action that we were injured or damaged by violation of these rights, if there's an argument in the underlying class action about summary judgment to that issue, that's not what's before the court today. Okay.
And then did you have a second part to this argument?
I was hoping you'd forget that, Your Honor.
Okay. It's all right.
I do think that that again, it just reverts back to, once again, this is exactly what what's alleged in the Fourth Amendment complaint of class action completely marries up to how they define a professional healthcare incident. There's probably a better second argument I can't think of right now. I didn't say threefold. That was good. Your Honors, have any questions? Okay,
Don't think we do. Thank you.
thank you.
Chris, you have a little more time for rebuttal?
Thank you, Your Honor. I'd like to begin first by addressing briefly the Zurich case and the Affinity Living case. I think counsel described the Zurich case as addressing a rising out of language. It does not. And that's what's significant. There were 3 insurance policies at issue there. All of them either used the phrase caused by or because of in the insuring agreement, which this court in the Affinity Living case distinguished because caused by is much narrower than a rising out of, which is what was at issue in the Affinity Living case. In the Affinity Living case, in reading through the decision, the phrase arising out of is the focal point of that entire decision. This court cites that 6 or 8 times, at least in its discussion, and then says this is different than caused by. Arising out of is much broader than caused by. Caused by has a proximate cause aspect to it. Second, the reference to the patient's Bill of Rights and the characterization of the Fourth Amendment complaint as advancing those types of claims. It doesn't. When looking at the Fourth Amendment complaint, there's a reference to 131D simply in the licensing aspect of the facility in the first couple of paragraphs of the complaint. Then it switches to the administrative code. There is no allegation in the complaint that Lake Point violated the rights, any rights of the residents under any state or federal law. Again, professional health care incident does not state any violation of state or federal law falls within the definition. It must be a right of a resident under state and federal law. So if you look at paragraph 20 of the First Amendment complaint, it alleges they were not in compliance with federal and state laws, rules, and regulations. It does not allege a violation of rights or failure to comply with rights. Same with paragraph 21. And then when you go to the paragraph, I think it's 50, that has, or 60, where the most citations are made, again, no allegation that they failed to comply with the right of a resident under a state or federal law. Instead, they did not staff, did not provide activities, and did not do the other things under the administrative code, which are licensing requirements. So that deals with professional health care incident and whether there really is an allegation of professional health care incident. But then that also leads back to caused by. So even if there were an allegation in the complaint that could be categorized as a professional health care incident, the injury still must be caused by that professional health care incident. What's the injury here? Assuming there's an injury. You didn't give us our money back. You overcharged us. We have a contract here. You charged us more than the services provided. We want our money back because we didn't get what we contracted for. It's not an allegation that Lake Point or the defendants violated our rights under state and federal law, and therefore we want damages caused by that. We want money because you overcharged us. And if overcharging falls within caused by in a breach of contract claim, it's not difficult to see how an insurance policy in a very broad variety of contexts, and many insurance policies use caused by. It's not hard to imagine how suddenly the insurance company is now paying for the debts of the insured. That's not what the insuring agreement provides. That's not what caused by provides, where there's a proximate cause connection between the injury and the professional health care incident. And when you have a straight breach of contract claim, that's not what you end up with when when that's the only claim asserted. So even if there is a professional health care incident alleged, the injury here, you're not giving us our money back, is not an injury caused by that. See, my time is
Thank
done.
you very much.
Thank you, Your Honor.
We appreciate the arguments, and we'd ask the clerk to adjourn court for the day. And unfortunately, we can't, usually at this time, we come down and shake hands, and we enjoy that tradition, but we're not going to be able to do it now. But we wish you well. Stay healthy.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.